Our next case is a Superior Court decision concerning the expenditure of Community Preservation Act money. The case is Silverio versus the town of North Andover. 17 North Andover taxpayers filed suit against the town to overturn town meeting's appropriation of $6 million from the Community Preservation Fund for the development of a sports complex at a park near the middle school. The town claimed these taxpayers had no standing to challenge the appropriation since they had experienced no harm or injury. The town of North Andover adopted the Community Preservation Act in 2001. The town also adopted a Community Preservation Committee bylaw. Under the terms of the statute, the Community Preservation Committee, the CPC, makes recommendations to town meeting for the acquisition, creation, and preservation of open space, and for the acquisition, creation, preservation, rehabilitation, and restoration of land for recreational use. Upon receiving the recommendation from the CPC, town meeting can make appropriations from the Community Preservation Fund and appropriate non-CPA money to carry out the recommendations of the committee. In the case at hand, town meeting appropriated $6 million from the Community Preservation Fund under the Open Space Recreation for a recreational complex. The project included baseball and softball fields, playgrounds, an exercise course, walking paths, restrooms, and concession buildings, a gazebo and shade pavilion, and parking areas. Included in the budget were artificial turf, drainage systems, fencing, lights, signage, and landscaping. The 17 taxpayers claimed the CPA did not authorize funding for public school projects, stadiums, artificial turf fields, service roads, parking lots, concession buildings, and restrooms. Plaintiffs also alleged that the project did not rehabilitate land for recreational use. Instead, they claimed the park was being redeveloped into a sports complex with new recreational uses. The plaintiffs filed their lawsuit under the 10 taxpayer statute, Chapter 40, Section 53, which allows taxpayers to act as private attorneys general to enforce laws protecting the public interest. Relying on a Supreme Judicial Court decision, Edwards v. City of Boston, decided back in 1990, the Superior Court judge held that specific personal harm or injury is not required to establish standing. The 17 taxpayers had standing according to the court, since the public has an interest in determining that CPA appropriated funds are legally spent. Having found that the plaintiffs had standing to challenge the appropriation, the judge then turns to the various claims raised in their complaint. Plaintiffs allege that the Community Preservation Act did not allow the use of these funds for public school purposes. The town attorney stated there would only be incidental use of the park by public school students. Relying on judicial notice, the judge scrutinized the CPA project's database maintained by the Community Preservation Coalition and discovered completed projects in other communities which involve public schools. In the court's opinion, this information demonstrated that CPA funds can be utilized where the public schools were not the primary beneficiaries of the project, and there was only incidental benefit from the site by the public schools. The plaintiffs also claim the project did not rehabilitate the land for recreational use, since it would redevelop the park into a sports complex with new recreational uses. The judge disagreed. He cited language in the statute, Chapter 44B, Section 5, which had been amended by the legislature to permit the creation of land for recreational use. According to the court, the project included the replacement of equipment and improvements to a rundown park, which brought the project within the definition of rehabilitation of open space recreational land. Plaintiffs also challenged the construction of bleachers with CPA funds, since the construction of a stadium is specifically prohibited under the terms of the CPA. The town stated there was a big difference between bleachers for Little League games and stadium seating. Little League bleachers provided low seating and were 27 feet in length. The judge agreed with the town and relied on a Supreme Judicial Court decision, Seach v. Canton in 1997, which interpreted the term recreation in the recreational use statute to include both active and passive recreation, such as watching baseball games and strolling in the park. The CPA itself, Chapter 44B, Section 2, also specifically defined recreational use to mean active or passive recreational use. Relying on these definitions, the judge ruled CPA funds could be used to construct bleachers, which would enable the public to make passive recreational use of the park. Regarding funding for artificial turf, the judge ruled Chapter 44B, Section 5 logically prohibited not only the purchase of artificial turf with CPA money, but also site preparation work for the installation of the artificial turf. The judge's disallowance of money for this phase of the project meant that the town would have to find some other funding source. Plaintiffs then challenged the expenditure of CPA money for a service road and a walkway through the park. The judge rejected plaintiff's argument since the CPA did not preclude a path constructed primarily for recreational purposes, such as for jogging or walking, from being incidentally used as a service road. Regarding parking facilities, field lighting, concession buildings, restrooms, and storage facilities, the judge observed that the CPA did not expressly prohibit them as it did artificial turf. In addition, a search of the CPA projects database disclosed many similar projects which had been funded with CPA money. Consequently, the Superior Court judge upheld all the CP appropriations except for the money for the artificial turf. In the aftermath, a motion for reconsideration was denied. Meanwhile, two related actions are pending in land court. One case concerns a special permit. The second is an adverse possession claim. The town of North Andover has not gone out to bid for this project due to the pending litigation and the rising construction costs after COVID-19. And with that, I conclude this portion of the program.